What he's alleging in 425 is a constitutional claim built on constructive eviction plus due process deprivation. That only works if he had a legally protected property interest and the government deprived him of it. Based on what you've described, there are serious structural weaknesses in that theory. Paragraph 4. Constructive eviction, 14th Amendment. To succeed on this, he must prove 1. He had a lawful possessory interest. 2. A state actor deprived him of it. 3. The deprivation occurred without due process. Property 1. 2020 N College Ave, commercial. If the property was zoned commercial, had no residential certificate of occupancy, was not permitted for RV habitation, and he was occupying an office space, then the threshold issue is fatal. He likely had no legally protected residential property interests to begin with. You cannot claim 14th Amendment deprivation of a housing right that zoning law does not recognize. Sleeping in an office does not convert it into protected residential tenancy. Additionally, if enforcement actions were directed at the property holder and no eviction was filed by the county, and he chose to leave, as previously stated in federal court, then there was no state executed eviction. Constructive eviction generally applies to landlord conduct making premises uninhabitable, not code enforcement notifying owners of violations. The government warning an owner of code violations is not equivalent to forcibly excluding an occupant. Paragraph 5. Landlord acted under influence, fear of police. He's attempting to convert a landlord's independent decision into state action via influence theory. For that to hold, he would need evidence of coercion beyond lawful enforcement, collusion, or abuse of authority outside statutory scope. If Gray identified violations, posted notice, communicated regulatory consequences, and did not order eviction, then the landlord's decision is not automatically attributable to the state. The fact that he feared confrontation or police involvement is subjective. Fear is not deprivation. Courts look at actual governmental action. If no officer ordered him removed, no trespass citation was issued, no eviction writ was executed, no court order barred him from access, then the deprivation argument becomes speculative. Property 2, Willocks Lane. Here the analysis shifts slightly because it's residentially zoned. However, converting a garage into living space without permits is a code violation. Living in a non-permitted accessory structure is a violation. Complaint was reportedly made by a third party. Gray posted notice, standard procedure. Fredrickson filmed and read the notice. He inserted himself into the inspection process. He claimed to be owner, which you state is false. He exchanged labor for lodging rather than holding a formal lease. He voluntarily left without eviction, as he did at Property 1. That undermines the claim of sudden deprivation, the claim of no notice, the claim of lack of procedural opportunity, the claim of eviction without process. If he voluntarily left again, the constructive eviction theory weakens substantially. Key legal pressure points. 1. Was he a tenant? You state he was not an owner, not a formal tenant, exchanging labor in lieu of rent. If he did not have a formal lease or recognized tenancy, then his claimed property interest becomes harder to establish. Labor for lodging arrangements are often revocable licenses rather than protected leaseholds. That matters constitutionally. 2. State action requirement for a 14th Amendment claim, he must show the government itself deprived him, not merely that a landlord reacted to regulatory notice. Code enforcement, eviction authority. If the county never filed eviction proceedings and never ordered his removal, that distinction is critical. On a 3, prior federal case admission. If he previously stated he chose to leave without eviction at both properties, that creates a major inconsistency with constructive eviction and forced displacement. Voluntary departure is legally different from state-imposed exclusion. The core structural weakness in his claim. His argument assumes, I was living somewhere, therefore I had constitutional housing protection. That is not how property rights work. Protection attaches to lawful tenancy, recognized possessory interest, lawful occupancy under zoning and building codes. If occupancy itself violates code, constitutional framing becomes extremely difficult. What this really comes down to, the case hinges on 1. Zoning classification, 2. Certificate of occupancy status, 3. Whether enforcement actions exceeded statutory authority. 4. Whether any government official ordered or executed removal. 5. Whether he had a legally recognized tenancy. 6. Whether prior sworn statements contradict current claims. If enforcement stayed within regulatory authority and no eviction was executed by the county, then calling this constructive eviction without due process is legally ambitious. If you want, I can help you outline how a motion to dismiss would frame the failure to establish protected property interest, state action, causation, or constitutional deprivation.